We are now live and on the record.
Thank you. Welcome to the appeals court. This is 20,000 P 1219 Commonwealth versus Gene Jackson. Ms. Martin.
Good afternoon, Your Honors. Lois Martin here on behalf of Mr. Jackson. I would like to start with the issue of the video being introduced. At the trial, the district attorney stated that during the hearing on the motion to eliminate, that it would tend to show that it would tend to make it more likely that defendant was the person there. But there really was no link. The description of my client was just a tall black man. It could have been any tall black man. As I note in my brief, he ran because not a lot of black people in that area didn't know what was happening, and none of that information came in.
Ms. Martin, the man depicted in the video had the black hat and the orange gloves that were
but he did not
found in the victim's driveway where there had been a scuffle.
But as I note in my reply brief, the man that had the black hat was Mr. Dodd, the victim, alleged victim, not Mr. Jackson. And the orange glove that was found at the scene was a garden glove. And the trial at page 185, 186, Officer, I can't think of his name, but the officer testified who arrested him that he was found with latex gloves on, which is different. Latex gloves are usually clear. So that would not indicate that that would be further testament, although it came out obviously later, but further testimony that the video was not reflective of my client. At trial, they noted Mr. Dodd and I should probably call him Mr. D. Mr. D testified that when he left, he had a black hat on. The black hat was only found after my client allegedly ran away from Mr. D, so that there really was no connection. Mr. D acknowledged he had a black clip hat on it, and
you know what interests me is that defense counsel at trial didn't try this as an ID case. Granted, the defendant was unwilling to stipulate that it was his identity, but it was a self-defense case. How is any of this prejudicial to you when he argued he acted in self-defense as opposed to I wasn't there?
Well, Your Honor, it's probably when you were attorneys practicing, sometimes clients change their mind. When I got the case, my client told me he wasn't there, and that's how I wrote my brief.
But we have to review the case based on what happened at trial.
Yes, exactly. But nevertheless, what happened at trial was that it came in this video. And again, I would just say, regardless of whether you saw the hat, I think I filed a motion to bring in a different picture, a stopped picture of the video, because I dispute at this after, that possibly it wasn't even an African-American man, but there was no probative, no link.
But the problem with your motion is that the jury actually saw this video, and we can't find facts on appeal. So the extrajudicial effort you've made in trying to identify the person in the video is not a proper matter on direct appeal for us to decide.
Okay. So back to the video that was presented to the jury. There was no date or time stamp. No one actually saw the man.
Didn't the victim testify as to when it was taken and what day and time when he knew about the incident on the 9th of November and accessed it on his video, on his phone app?
No, it was a neighbor 4 doors down and 1 over back. So it wasn't Mr.
Oh, I'm
D.
sorry, you're right. It wasn't Mr. Dodd. It was the neighbor. Excuse me. Who said when it was taken?
Yes, but he didn't really know. All he knows that was he went to his phone, looked this up, and there was a video docketed at that date, and time. But he wasn't there. He never testified about whether or not even anybody was in the house when this person allegedly looked inside.
Why wouldn't that go to the weight of the evidence as opposed to its admissibility?
Well, it could, but the issue really is, was this prejudicial? Was this video more prejudicial than probative? The Commonwealth says it was minimally prejudicial, and I suggest it was more than minimal, because it indicated that a man that had been at a house, as I say, 4 houses down and 1 over, could have then been the man that was in the house when Mr. D came back to his house. And there really was no connection made, except that there possibly were 2 men in the area. Who knows? You know, we don't have that kind of judgment.
Judge Heffernan gave the defense an opportunity to keep the video out.
Yes, well, that is an issue that my client, I think it reflects some of the issues that one has with one's client sometimes, to be, vividly honest about that. Trial counsel was very successful. He convinced the jury to find Mr. Jackson not guilty of the assault with a dangerous weapon, assault and battery. The only charge that he was convicted of was the breaking and entering. And the only connection that brought Mr. Jackson to that house, so allegedly, or besides Mr. D's testimony, was the video. So the video to me seems a lot more important.
Well, the victim testified that he saw him inside the house, right? Looking at bicycles.
Yes.
So there's more than the video.
Well, it's an issue of Mr. D's testimony, whether one believes his testimony or not. The jury evidently did believe his testimony, which was supported by the video. In other words, they didn't believe his testimony on the assault and battery and the assault dangerous weapon, but they evidently, with the support of the video. That's why I think the video was so prejudicial, because without it possibly Mr. Jackson would have been found not guilty of the breaking and entering also, because it was clear the jury had no support or had questions about Mr. D. Okay. With regard to the other issue, which was the show up identification, that is disfavored. It doesn't make sense to me, to be honest, why police departments keep drawing up these standards that never seem to be followed. Newton Police Department, and this was a Newton case, had a very clear, distinct outline, General Order 409, I believe, that was not at all followed. The officer basically read over the witness advisements, which was introduced as Commonwealth's Exhibit number 1, but he didn't bother to have him, and it shows little lines for the person to sign that he knows, that he understands what he's saying. Even that was not followed. Admittedly,
he did testify that he gave him the German warning, or the Origin Silva Santiago instruction. And the Commonwealth concedes it would have been nice if he had initialed each box, but he testified that the witness understood the warnings and the judge credited the officer's testimony.
Yes, but how does he know that the witness understood it? He basically read it to him. He didn't ask him to explain it back to him, even if he didn't use the Newton.
He could have nodded along, as far as we know. But we do know is that.
I'm sorry, I didn't understand what you said.
He could have been nodding while he explained it, for all we know. But what's important is that the witness testified that he understood the warning, and the judge credited that witness's testimony.
That is true, but the fact is that he was arrested for possibly breaking and entering. This is what happened before the show up. They didn't, and possibly the officers knew there had been physical violence or potential violence involved. But that was it. Why couldn't they have taken him to the police station and had a lineup? There was no weapon. At that point, no weapon was known that had been involved in this case at all. And even that weapon was when it was found was a closed knife, pocket knife.
Well,
So
I honestly think that you know the answer to that question. And to do a lineup, it would take some amount of time, which would require your client to be held in custody. Whereas if the witness could not identify him, he would be immediately released, and then they continue to look for the actual perpetrator.
but, and the issue is obviously of public safety if we have a violent, dangerous person running around the streets. But that did not appear from what Mr. D said, that was really that violent a person. I'm not saying there wasn't a dust up and stuff, but it didn't sound like we're talking about some young kid that possibly could have really harmed Mr. D. Talking about an older man who's trying to get away. So it didn't reflect that someone that was the initial situation did not reflect that there was such a major public safety issue that they couldn't take him into custody and bring him to the station. It's, as the Moore court case says, it's in an unbiased lineup, an unreliable witness will often be exposed by a false positive response. By contrast, show-ups involve a lone suspect. Every witness who guesses will positively identify the suspect. I mean, the officer didn't even say to him, he said, we have someone, but he didn't say that we're not sure if that's the person. He gave him no indication that maybe, there was any doubt. He basically said, we've got him. And when Mr. D was brought there, he supported that. There was no doubt at all. And after they had been in this dust up, I don't know how old Mr. D is, but it sounded like they had, it was turmoil, but nothing radical. He didn't seek out any medical help afterwards or anything. I'm sorry, Judge. Oh, I thought. So it just seems that it was disfavored and I would suggest unnecessarily suggestive. There was just no good reason that they couldn't have had a lineup on this, and a lineup, and that they should have followed their own procedures. It does really make one question. I mean, in the Meade case, the Lowell Police Department, which was four defendants, and they had, I think, 3 witnesses. Lowell has as I said in my brief, very similar questions and format to be followed for show-ups. And they did it, and the court, of course, upheld it because it was handled in a proper manner. But in this case, it wasn't really handled in a proper manner, I would suggest. And for those reasons, I think it should have been a lineup. Well, if there's no other further questions, I'll rest on my briefs.
Thank you, Mr. Fareder.
Thank you. Good afternoon. If it may please the court, Timothy Fareder, Assistant District Attorney from Middlesex, on behalf of the Commonwealth. I'll start with the video. The video was properly admitted, it was properly authenticated. The neighbor testified that his house backs up to Harrington Street, the scene of the crime, testified that he had a Ring doorbell camera, and then upon learning about the crime, he was able to use his app on his phone to select the date and time around 7 p.m., the time of the crime. And so for that reason, it's properly authenticated. The video was very probative. It put the defendant in the area of the crime at the time of the crime, wearing a black knit hat and orange glove, which were recovered on the scene. This was a case where the ID was only based on one witness whose credibility was being severely attacked on cross-examination as being racist. And so for those reasons, the video was very probative, properly authenticated, and properly admitted. And if the defendant wanted to challenge that it was not him on the video or as a person of a different race, the proper time to do that was before the trial judge, who had the defendant sitting in front of her at the time and could have observed the video and observed the defendant. Moving on to the show-up identification, all the factors weigh in favor of this being a proper show-up identification. It was done shortly after the crime when the victim's memory was most intact, and it was done quickly within 15 minutes of the crime of the dispatch, and allowed the police to either learn that this was the defendant or was the perpetrator or not, and to continue their investigation or to arrest this person. The victim was properly warned pursuant to German, including the second warning that this may or may not be the person who committed the crime. And for those reasons, it was a proper show-up identification, where at the identification, there was two officers standing 10 to 15 feet away from the defendant, and this was not impermissibly suggestive. Is there any other questions? I'd be happy to take them. If not, I'll rest on my brief.
Seeing none, thank you. Thank you both. We'll take